Today we will be discussing pretrial preparation. Before trial, volumes of documents must be organized, and other pretrial matters must be taken care of as well. This video will introduce you to the preparations that must be done prior to trial. After this video, you should be able to identify the motions filed before trial, explain what goes into a trial notebook, identify the paralegal's role in preparing witnesses, preparing trial exhibits and briefs, coordinating trial logistics, and explaining a paralegal's role with respect to the jury process. The paralegal may be asked to assist with drafting motions for inclusion in the trial notebook. A motion in limine is one of the first motions filed before or at the beginning of trial. In limine is defined as at the threshold. Such motions are frequently used to prevent opposing counsel from introducing certain evidence at trial. Motions in limine often attempt to exclude an opponent's expert witness or an expert opinion. Success in this area can severely damage the opposition's case and possibility of success. The trial notebook is a vital part of any trial preparation. This is usually the paralegal's responsibility to prepare the notebook for the attorneys. The trial notebook is a binder that contains, in complete or summary form, everything necessary to prosecute or defend a case. Preparation of a trial notebook, like the preparation of the trial itself, begins with the initial interview of the clients. The contents are organized and determined by the individual preference of the attorney or the paralegal. The form of the notebook is also dictated by the type of case, the number of pleadings, the complexity of legal issues, and the number of exhibits and witnesses. However, most trial notebooks include the following basic sections: information regarding the parties and the attorneys, pleadings, motions, and discovery responses, information regarding the witnesses, information regarding the expert witnesses, document indices, deposition summaries, chronologies, a cast of characters, legal research, trial exhibits, juror profiles and instructions, a trial outline, attorney's notes, and a list of things to do. As a paralegal, you will be instrumental in preparing the witnesses for trial. One task that you may have to perform is arranging for the sending of subpoenas to certain witnesses. You may also be charged with communicating the details of the trial to the witnesses. Finally, you may be required to arrange and attend all witness preparation meetings. You must consult with your attorney to determine if any witnesses will require a subpoena. In some instances, attorneys prefer to subpoena only witnesses who are not considered friendly. However, a friendly witness may request a subpoena to present to an employer as evidence that she has been ordered to appear and testify. The preparation of a witness for trial is much more involved and generally much more critical than the preparation of the witness for a deposition. Therefore, it is usually advantageous for the paralegal to work with the witnesses in the case from the time of the initial interview. This early involvement will build a relationship that facilitates communication and helps put the witnesses at ease while working with the paralegal. Now, shortly before the trial, the paralegal should arrange a meeting between each witness and your attorney. Before the meeting, you may be asked to collect all documents that refer to the witness. You should review the witness's deposition and note any areas that gave the witness difficulty or that may require further clarification. Now, often, the paralegal is called upon to gather and organize the exhibits in a case. With respect to trial exhibits, the paralegal may be required to prepare a trial exhibit list, a trial exhibit log, enlarged exhibits or unusual graphics, a chronology of the case, or may be asked to evaluate documents to be used as trial exhibits. A paralegal may also be responsible for providing research to be included in the trial brief. A trial brief explains the legal issues involved in the case and the law that demonstrates the validity of the position your attorney has taken in relation to those issues. Your role and the preparation of the trial brief consist of legal and factual research. For example, your attorney may request that you locate specific testimony from a particular witness's deposition. You may also be asked to determine the validity of the cases cited in the brief. The paralegal is often responsible for coordinating the preparation and filing of the brief with the court, so therefore you should be familiar with your local rules pertaining to the form of the brief and the number of copies needed and the time for filing. The paralegal is often responsible for coordinating the logistics of a trial. If the trial is held at the local court or where your attorney usually works, coordinating the logistics will be a routine matter. However, when the trial is held in another district or another county, or when your client and many of the witnesses are from out of town, you will have to arrange for accommodations. Also, for both local and out-of-town trials, you will have to examine the courthouse and contact local court personnel. Court personnel include the court clerk or the court reporter. There are several factors that should be considered when choosing a judge or a jury trial. Some of the factors to consider include the complexity of the case, the availability and condition of the client, and the location of the trial. If the plaintiff wants a jury trial, they will have to request it at the beginning of the litigation. In the past, planning for, conducting, and winning a case before a jury were largely matters of chance. Today, however, attorneys have a wide variety of tools at their disposal to help them maximize the effectiveness of a jury trial. These techniques include the juror profile and the mock jury trial. The purpose of the juror profile is to determine a composite profile of the ideal jurors for a particular case. Social psychologists and litigation specialists are equipped to provide law firms with valuable statistics and jury sampling information. The statistics and information are designed to create not only the image of the preferred jurors, but also profile of the jurors that your attorney will want to avoid. Many firms stage mock trials prior to the date of the actual trial. A mock trial is a practice trial. The paralegal is often responsible for arranging the mock trial. The first step in the mock trial is to select the mock jury. A mock jury is a group of independent individuals chosen to reflect the probable makeup of the actual jury. Once the mock jury panel is selected, your firm presents the mock trial. The witnesses and principal exhibits are presented to the jury in the same way they would be presented at the actual trial. For best results, a juror should not know which side your law firm represents. Thank you for watching today's video. Please proceed with completing this week's activities.